Can I give you an opportunity to respond to the amicus brief from General Myers and Admiral Mullen, which says, among other things, that the Fifth Circuit's approach would set a dangerous precedent that could adversely impact our national security, discouraging private parties from taking direction from federal officers for fear of future liability, weakens our armed forces while strengthening our enemies. Devastating implications for our national defense are not hypothetical. After September 11th, for example, our nation needed specialized protective equipment, which the military did not have. If private sector parties producing the equipment had said no, fearing future liability, that would have left our troops at great risk. So I just want to give you an opportunity to respond to that fairly strongly worded amicus brief from General Myers and Admiral Mullen.
Yes, Justice Kavanaugh. The thing I'd say to that is my friends on the other side say we're trying to take the court's precedents back to pre-2011 standard. I think if that were true, then we would have seen evidence of all of this parade of horribles for the decades that this court's removal precedents required exactly what they say we're trying to return the court to. You don't see anything in those briefs, and like I admit, the rhetoric's strong, but where are the examples of the government contractors who said, man, before 2011, because of the federal officer removal statute, the way it's been interpreted by the Supreme Court, we're not going to engage in contracting like we'd like to. You don't see anything in the amicus briefs on that point, Your Honor. And so I think you should take the rhetoric from lawyers' pens for what it is. And, I made the point with Justice Jackson earlier that our theory of the case is perfectly consistent with all of the asbestos cases, which is the mine run removal case that the federal courts are going to see. And so with all due respect, the rhetoric is unfounded.